All right. Good morning, everyone. Let's get started. We have a mixed calendar this morning, some plea and arraignment. Looks like it's got a few other items tucked in there, but we will plow through it in the order it was published. Position one. Hello, Miss Charles.
Good morning, Your Honor.
How are you?
I'm well. I'll be back.
It's nice to have you back. Maybe you'll stay for a little while.
Hopefully.
Position one is Mr. Johnson. And I think, Ms. Rios, you've already done a waiver, so we'll get a scheduling order done. We're working through a bench warrant issue today.
Yes, and the state has already consented to send the federal district.
Because
he was in custody. I emailed Ms. Nelson and the state proved that he was in custody at the time he missed court.
Okay. Does the fact that he was in custody when he missed court make us excited about the fact that he should stay out on bond on the original charges?
Well, I think it's just, he would have come to court if he was not in custody.
Right, if he hadn't been arrested for something else.
Yeah.
Yeah, and so I'm just curious what the something else was and why that would mean we would think it's great that he's out on bond on older charges if he picked up newer charges while on bond.
I will have to look at my notes.
Okay, I don't mean to put you on the spot, but I'm gonna want to work through that part. I think that the state correctly said, hey, he couldn't have been here. He was stuck somewhere else. But if the reason that somewhere else was jail and he was in jail because he picked up new charges, that to me raises the question of should he remain on bond for the older charges? And partly it just depends what it is. I mean, I'm looking at these charges, probably Mr. Johnson needs to get connected with some support services. But he's here and we can talk, if you don't mind, when you're not on, looking up what got him locked up. That would be great, and we'll talk about that. All right, Charles Carter.
He's in custody, Judge. He's mine. Good morning.
Good morning.
Miss Dilligard and I have been talking about this one. It's not ready to go yet because I think there might be something else we might want to wrap in with it. So I'll do a waiver today.
Okay, something else, meaning it looks like it's a pattern of the same thing.
Yes.
And so it would just be more of the same thing?
I think, is it the same location? Okay, yes.
Is he breaking into storage units
No, it's copper wiring from HVAC units.
of abandoned houses or occupied houses?
Apartment complex.
Apartment complex, same apartment complex?
Yes, Judge.
Just with lots of HVAC units?
Lots of
Huh. Okay. So there may just be further instances of that haven't caught up to him.
Yes.
Got it. Yeah, because it has two booking numbers for him. Oh, because he had an FTA. All right, so you'll do a waiver, and we will move this along.
Thank you.
You bet. Do you want me to chat with Mr. Carter?
I just need to briefly speak with him, but I think we don't have to bring him out.
Okay. Shelby Gardner.
Good morning.
Good morning.
John Tate.
Hey, Mr. Tate, how are you?
I'm fine. How are you today?
I'm all right. Where's Mr. Gardner?
It's Ms. Gardner.
Ms. Gardner. Hello, Ms. Gardner. Hey, you're here too. Excellent. So Mr. Tate, we're here for plea and arraignment. And it may be that Ms. Gardner wants to waive arraignment. That's up to the two of you, in which case there's a form I'll have you fill out that waives arraignment. And then you indicate on that form whether you're opting into discovery. And then I can chat real briefly with you two, or you may want to have Ms. Gardner formally arraigned. That's your call.
I think that we could waive the arraignment.
Okay. Why don't you grab, actually Deputy Gordon will get it for you, the waiver of arraignment form. And then Ms. Gardner, I've got a few questions for you. Whoops. Oh, you've got a co-defendant, Mr. Foster, but you've already done a waiver for is Mr. Foster here? He is here, okay. You've already done a waiver, Ms. Rios, for Mr. Foster.
Yes, sir.
Got it. Let's start with Ms. Gardner. Ms. Gardner, are you and Mr. Foster connected in some way, related, relationship, kid together?
Yeah, he's the father of my two kids.
Okay. How many kids total do you have?
I have two.
Okay, and he's the father of both?
Yes.
Got it. All right. I have as an address for you something on Timothy Drive. Is that a good address, or have you moved?
I have moved since then.
Okay. Your lawyer, Mr. Tate's going to need to fill out another form, which Deputy Gordon is getting, and that's the change of address form, so that when we send notices, they'll always go to your lawyer and he'll know and he'll probably call you, but they need to go to you as well. And right now your notices are going to Timothy Drive. So if you can help your lawyer with the correct address. And so this is an old case. You've been on bond for a while now, and I'm just checking your bond to see if there's anything we need to talk about. You're supposed to be complying with the safety plan that got put in place, but that was put in place a while ago. Is it still in place?
We actually worked out a situation where my mom has guardianship of my son. And with that being said, the defense case was closed in December of 2024.
Probably, because 2023 is when you were in front of Judge Hughes and she said, hey, you have to follow this plan.
Right, so I want to say maybe a couple of weeks after that,
Oh.
they got with defense to where my mom has guardianship of my son.
Okay,
So we got the case closed before. I want to say I usually got the letter in January.
okay, of 2024. Okay, so much time has passed. It doesn't seem like you have to have no contact with anyone in particular. It was to follow the safety plan, but now with that guardianship in place, but that's as to just one of your children.
Correct.
Okay, great. Then I've talked to you about the things I need to talk about. What's going to happen next? Your lawyer's filling out those forms. Waiving arraignment just means he's entering a plea of not guilty for you. The prosecutor in your case, who will be
ADA Clark, Judge.
Ms. Clark, who's not here right now, she's going to get discovery to your lawyer. And Mr. Foster, same thing's happening in your case. It's just the discovery is going to go to Ms. Rios, not to Mr. Tate. Same discovery. That's just the paperwork that the police generated. So it could be a police report, it could be an interview, if there was body cam and you were talking to an officer, that all gets recorded and you're entitled to get that, your lawyer is. So you and your lawyer will look over that, and then we'll either be back here because there's been a motion filed, or people have started to work the case out. And if the case isn't going to work out, then we have a trial and we bring you back here for trial. So I ought to see both of you next, either because the case has been worked out, or there's a motion that needs to be argued, or either or both of you have said, I want a jury to hear this evidence and decide how to resolve this case. Any questions about any of that, Ms. Gardner? Okay, you're welcome to take a seat. Confirm, please, with Mr. Tate that he's putting all the right info on those forms. Okay, Mr. Foster, let's turn to you, sir. And much of what I said to Ms. Gardner applies to you about the schedule and all that. Looks like your bond was pretty similar, and the same day with Judge Hughes, you were supposed to follow the safety plan, but it sounds like that case has been closed out. Do you have other kids besides the two that you have with Ms. Gardner?
I have 5 and I have 3 more.
Okay. Your bond doesn't say anything about that situation. So as long as you're doing whatever got sorted out with DFACS, it seems like you're good to go in this case. Do you have any questions about anything?
When I first got charged, it was on their 2nd degree, and right now it's showing that I'm being charged on the 1st degree.
Right. So when you get arrested and the police take out a warrant, they're acting on the limited information they have. They're not lawyers. And so they write down the charge that they think best fits the situation. And then all of the police information goes to the district attorney's office, where lawyers who know better about the elements of the different crimes look at it. And someone in the district attorney's office looked at the allegations against you and against Ms. Gardner and concluded that what is alleged to have happened to Parker Foster constituted cruelty in the first and not cruelty in the second. So you and Ms. Gardner are in fact charged with 3 counts of cruelty in the first, but those are just allegations. That's what the state believes the evidence is in this case. You and your lawyer will be looking at it and you may end up agreeing, yeah, actually that's a better fit, or we disagree. And really the way this case needs to work out is we plead to a lesser of second degree, or who knows? You're going to be in the good hands of Ms. Rios in terms of navigating that. Okay. Any other questions? Ms. Rios, do you, oh, let me check, Mr. Foster, in terms of your, I've got a King Arnold Street address, apartment D4. All right, we're good with that. Ms. Rios, anything else in connection with Mr. Foster? Need him to stick around? All right. Mr. Tate, anything else on behalf of Ms. Gardner?
No, Your Honor.
Okay, once those 2 forms are filled out, if you get them to Deputy Gordon, you and Ms. Gardner are free to go. And I'm sorry, the prosecutor's not here, so you don't meet her and get her contact information, but I'm sure she'll be reaching out to you soon to get discovery to you. Okay?
Thank you so much, Your Honor.
You bet. If you don't have anything else, you're free to go.
Have a great day.
Tremaine Denson shouldn't be here. He waived arraignment and was excused. How about Dion Travis Stafford?
Judge, he is in DOC custody
Oh,
until next week. It looks like his max out date is. I sent an email. I think he's probably going to be brought directly back here because it looks like he never posted the bond that he had when this was in pre-indictment.
okay. So he's got a bond and he may be able to make it, but he just, that process never happened.
Correct.
Okay. I guess we'll let Ms. Nelson think through the best way to get him back on the calendar. I guess it could be a little bumpy if he bonds out right away.
Great.
I don't know. This is an old arrest, so who knows what the correct address is, but I don't know when you check out of jail, the bonding company ought to have a good address for him then.
Yes, and when I was looking, he was in custody here for like over 200 days, so I don't know if he'll be able to make that bond.
Got it. Okay,
But I'm gonna keep my eye on it.
great. And as soon as he's back, we can add him as a supplement to a Zoom calendar or whatever.
Yes, Judge, I think it's something we can probably work out pretty easily.
Okay. Ronald Jones.
I believe he would be my client, but I don't have any contact information for him.
Okay, semi-recent arrest. Ms. Charles, is that your case?
Subject to treatment, still request match warrant.
Okay. We'll call his name one more time when we're done here. How about Daniel Jackson? I don't have a bond listed at all for this case. But the arrest is, I'm amazed this thing's already indicted. Look this up. Oh, it got dismissed, so that might have confused him. And then 2 days later, he got indicted. The officer didn't show up. Okay. Bench warrant? All right. Tanaya Tillman? Hello, Ms. Tillman.
Judge, she will be mine. I'll do a waiver today, but I do need to connect with her and get some updated contact information.
Got it. Ms. Tillman, I'm Judge McBurney. I don't think we've met before. Ms. Wood is going to be representing you, and she's going to want to talk to you before you go today to get a little bit of contact information. Let me pull your case up here on the screen. Do you know what you're charged with? Okay, it's along those lines. Let me look at, this relates back to something that allegedly happened a long time ago, December of 2023, probably. Yeah, so you're charged with an assault on a gentleman by the name of Eric Rankins. And it's aggravated assault and then battery. It all relates to the same thing that supposedly happened on December 13th, 2023. Ms. Wood will get you a copy of that indictment and the discovery when she gets the discovery. In looking at your bond, you are supposed to, says no violent contact with Eric Rankins, which says to me that for whatever reason, the prosecutor back in December of 23 thought that you two could still be around each other. It just needed to be nonviolent contact. Is Mr. Rankins someone who's still in your life?
Somewhat, it's complicated.
Okay, it's often complicated. Is he someone with whom you're occasionally romantically involved, or is he a relative, or do you guys have kids together?
Yeah, we're probably.
Okay, you're not relatives and romantic, it's just yes to the romantically involved part. Okay, all right. Last thing, I want to make sure we've got a good address for you. What we have in the system is Jimmy Thomas Court in Snellville. Well, that's a good address. What's the best address? Okay, who lives at Jimmy Thomas Court? Whose mother? So you don't live there and he doesn't live there, but his mom lives there. And that's the best place for mail to go?
Yes, that's where I get all my mail.
Okay, and even though you and Mr. Rankin sometimes have some disagreements, his mother is on good terms with you? Does she blame him? No? Okay, but that's a safe place for mail to go. Do you have a stable address or are you moving about some?
That's complicated as well.
Okay, sounds like you have a complicated life.
Yeah, a little bit.
Okay, well, hopefully you have a stable phone number and email address because Ms. Wood's gonna wanna get those from you. I don't need those, but she will so that she can be in touch with you when she needs to meet with you about your case, okay? Is this gonna be your case, Ms. Charles?
It will be.
Okay, popular calendar for you. Anything from the state in connection with Ms. Tillman's case?
This was positive for parents. I get discovery. I will stop talking.
Okay, so Ms. Wood, you'll do the waiver, you'll get the discovery, and Ms. Tillman, Ms. Wood will then want to meet with you once she gets all the paperwork in the case, so she can talk to you about what this is all about. And you can explain to her how it's complicated, okay? All right, Ms. Wood, anything else?
No, Your Honor, thank you.
All right, so Ms. Tillman, you need to stay until Ms. Wood says you can go. Once she says, great, I've got what I need, then you're free to go. India Albert. Hi, Ms. Albert. Your lawyer filed a waiver of arraignment already and asked that he be excused and that you be excused. So it's smart that you were here, just in case, but you're free to go. He gave us the green light on everything, okay?
Thank you so much.
All right, thank you for being here. Then we get into some probation revocations. Who is representing Mr. Dorr?
I am Your Honor.
You are, all right. Have you spoken with Ms. Dilligard about this one yet?
She was including the emails to probation, so I know what the probation's asking for.
Okay, I mean, you all have been talking, or at least you've been on emails? Okay, do we need to do anything we'll bring Mr. Dorr out in a minute, but do I need to do anything or we should bring him out and we can do the hearing today?
We can do the hearing.
Okay. All right, Mr. Arnold has two positions and I've been told that Mr. Render is going to handle Mr. Arnold's two cases. Is that still true, Ms. Nelson?
Yes, and he'll be signing on around 9:30. He'll be on Zoom call.
All right, so Ms. Wood, you don't have to worry about Mr. Arnold. Then we get to Victor Leach.
I will be handling his case, Your Honor.
Okay, is that one that's ready to go or do you need to talk to him or to?
You can go.
We're ready, okay. Then Mr. Arnold is on again. And then we've got Ms. Recky, who isn't here yet. She will be here. She just hadn't made it over here yet.
Judge, that's fine. I'm happy to speak with her. I saw her I don't know if you remember Miss Recky.
Once I saw her picture, I remembered Ms. Recky.
She has a few new struggles, more so than she did the last time we saw her.
Mm.
So I was going to request a reset. I might have to do an evaluation. I've got Miss Ross involved already.
Okay, she was always on the cusp of that. And just seeing what her address was, it sounds like things are transitional for her.
Yes.
Okay.
Yes.
So when she's here, you should chat with her. If we all need to chat briefly, that's fine. Reset. I get it. We'll do what we need to do. I think. Find her. Yeah, so hers are all technical, but they're related to stability. And so it would be great if Ms. Ross is involved, and it may be, like you said, that we need to have an evaluation. Okay. That is it for the regular calendar. We have two add-ons. We have Mr., is it pronounced Robida or Robida, Mr. Apt?
It's Robita, Your Honor.
All right. You don't need to come all the way up yet, but we're here to talk about modifying probation. Is that, I'm looking at that's the case you've been talking to Ms. Dilligard about?
It is, and I think we reached a consent agreement, Your Honor. So what I would like to do, if the court would allow it, is, and Ms. Dilligard agrees, is present the court with a consent order. Ms. Dilligard is going to need some documentation from my client.
Where is he?
Thank
He's right there. Okay, great. We'll come back to it in just a sec. I just want to make sure we got the pieces in place.
you, Your Honor.
You bet. And then we have it's entitled a motion to recall FTA status. I think it's dealing with a bench warrant involving Howard Cassels. I don't see his lawyer here.
Judge,
Maybe
we're
he's,
holding for his report. He had a conflict. He'll be probably here around, I do believe he said 10:30 or 11.
okay, well, that one will wait. All right, so we'll hold on that. Have you had a chance to speak with the attorney for Mr. Cassels?
No, Judge, I haven't.
Okay, well, he will be here. Then why don't we close out with Mr. Robita and Mr. Apt, and then we can pivot to our revocations. Let me call the bench warrant names again, just in case someone showed up. Ronald Jones, Daniel Jackson. Is it? Okay. You two gentlemen, are you here for folks who are in custody today? Okay,
Mr. Holmes.
got it. Sir, who are you here for?
My name is Jeremy Williams.
Okay.
Here to court for motion.
For
Set for the motion here.
a what hearing?
A motion is in.
Okay. Do you have a case number? Okay. Can you share the case number with me? You can just say it. I mean, I'll just type it right in because we may be able to get Mr. Williams on his way.
It is 24 SC 005465.
All right. Give me 1 second. All right. Your case is with Judge Farmer. He is in courtroom 4E or D. He's on the 4th floor. I've got the date for the motions hearing to be April 2 rather than today, but I'm not Judge Farmer, and so I don't want to excuse you in case the system is showing the wrong day. But what I can tell you is, he is on the fourth floor. Do we know what, is it four? I think it's D Delta. So same letter as this, 4 floors down. You might want to poke your head in that courtroom to see if there are folks in there and they could give you guidance. And your lawyer, Ms. Harrison, might even be in there, okay? So your docket is showing that you have a motions hearing on April 2nd. But you're already here, so you might as well swing by 4D, Judge Farmer's courtroom, because you seem to think it was today, and maybe the system's not right, and maybe you're right. You're just in the wrong courtroom. Okay?
Do you have, can you talk to Ms. Harrison? Or I can get his contact and send it to Ms. Harrison.
Excellent. That's his,
Nah, he's no the came in.
okay. Who's Mr. Mosley? Hey, Mr. Mosley, do you have a case number?
I don't know it.
You don't know it. All right, I'm gonna look you up because you're not on any of our calendars today.
My client.
Oh, it is your client?
Yeah.
All right, Ms. Rios can manage this one.
Yeah.
All right, maybe Ms. Rios wanted to see you today. Here she is.
You're gonna do something like this with excuse?
You're done? Yep, but you'll come back on future days. All right, great to see you. Mr. Apt, let's talk about Mr. Robita. Let me get his case on the screen. It's from way back when. So he entered a first offender plea and he has not much probation and then a suspended sentence.
Correct, Your Honor. So
Do you know how much remains on his sentence?
9 months, something like that.
Even better. 7 months, 9 days. Okay.
And I'd like to refresh the court's memory about this case. Mr. Robita had a bad drug problem. He was addicted to cocaine and other drugs. He was arrested. He then voluntarily went into inpatient rehabilitation, did intensive outpatient rehabilitation, and he's been clean and sober for, I think, 4 years now, and continues to attend regular meetings and ensure his sobriety. He's also an executive at a pretty good company and makes a pretty healthy income. But he is a company that manufactures resins. I'm not even sure I know what a resin is. I think that's some type of plastic. In any event, he's an executive there, and as part of his job, Your Honor, he has to travel both out of state and internationally. And shame on me, Your Honor, because at the time of his plea, he leaned over to me and whispered, like, is travel going to be a problem? And I said, no, you just ask probation. They'll give you permission as long as, you tell them in advance. I don't think that's an issue.
Right.
Of course, I think I
Got a turn.
Maybe 30 years I'm getting too old to get this right. So I guess that is a problem for probation, and it was a problem for Ms. Dilligard's predecessor. They would not consent, even though we provided, description of what he does and documentation and everything else. And I don't know why. I would think the state and the court would want him to be successful. So that's why we're here. I think Ms. Dilligard has and I'm very appreciative to have spoken with her this morning and appreciate her professionalism and want to thank her on the record because I think she gets it. And I am hoping the court gets it and that he can travel for work. And he'll have to provide some, whatever documentation it is, and then he can continue his job if the court would allow that.
Mr. Robita, do you travel out of state or out of country with your resin work?
Mostly out of state. Prior to COVID, I was out of country a lot. Since COVID, we don't travel internationally very much, maybe once a year at the most. But out of state, once every other month or so, roughly.
Okay, and is out of state Alabama or is out of state Washington?
It's Kalamazoo, Michigan, Wallingford, Connecticut, and Willow Island, West Virginia.
Is that because there are chemical plants in those places?
Yeah, our manufacturing sites are located there.
What's your favorite resin?
I would say amino crosslinkers.
And what do you do with that?
It's used for tire automotive, so every single car has our product in it, in the paint, in the base coat. So there's a base coat and a clear coat in the paint. And our product is the clear coat and partially in the base coat. And that prevents scratching and adds durability, promotes tire adhesion on rubber, so Goodyear, Bridgestone are all our customers.
Okay. And Mr. App suggested that you're an executive. Are you, what's your role in the resin company?
So my official title is Global Product Line Manager for Crosslinker Resins. So I manage pricing, manage margins, manage sourcing strategy, manage key projects.
What's the name of the company?
All next?
All Next?
Yeah, ALLNEX.
Okay. If I modified your probation, I would need to talk with probation about how we frame this language to allow for out-of-state but not international travel. And when I say probation, keep in mind, we're only talking about 7 more months. And so if you are able to put off until 8 months from now, a trip to Nicaragua to get resins from there, wherever you'd end up going, then we don't have an issue. I am not uncomfortable with you traveling out of the state of Georgia, but staying within, it sounds like it's well within the continental United States. You listed these 3 places. You're going to these exciting chemical plants. I don't have an issue with that, but I prefer to keep it domestic travel rather than international travel. Not because you're going to disappear. Disappearing is not the issue. I just want you to be in places where you're safe and are focused on remaining sober. And you end up in a faraway place with new temptations and challenges. And let's just get a little more stability under your belt before you do that.
No, I fully understand, and I'll do everything I can to push off international travel.
If something like that comes up, the process is this. You let Mr. App know, not the day before you need to go, because that's not realistic that you'd only learn the day before, that you have to go to the Resin Fest in Barcelona. We all know about that months in advance. And you let him know months in advance so that then I can work with probation and get the input of the prosecutor about whether you should go overseas or not. Okay?
Thank you.
Is it as simple, Ms. Simpson, as doing an order that modifies probation to allow domestic US travel? Or it's, how would we go about this?
That's more interesting versus doing a travel permit. I don't see why you wouldn't be able to just do an order just specifically stating that.
Yeah.
If anything arises from it, I'll have my chief look it over,
Okay.
but I don't see why that should be a problem.
So why don't we try that? My proposal, and you are agreeing to all this, Ms. Dilligard?
Yes, Judge. I reached out to probation prior to the hearing because nothing jumped out at me for a reason why he couldn't travel domestically. And so I think the issue is just that there wasn't a lot of documentation on what his position was, where he worked and things like that. And that was the issue. So I think with that proper documentation, the state has no objection to him traveling domestically. And I want to congratulate Mr. Robita on his sobriety thus far.
He's not been in trouble.
Good. No, that's what it sounds like. I don't think Mr. App would be crowing in this way if you were about to read from your screen. Well, except for the 5 positive drug tests, that would be a problem. And so we ought to celebrate and reward this focus on staying sober and being a productive member of our community. So we'll try that. If they create some hiccup, it won't be a hiccup for you. You should travel. But if you're getting friction from probation, let Mr. App know. Then I'll just figure out how to word it differently. It's doable. Worst case scenario, you would have to get them your itinerary before. Do you typically fly to these places, or is there a resin van? Okay, so you're going to buy a ticket and all you do is share that itinerary with probation saying, look, I'm going to Kalamazoo. I leave this day, I come back that day. I just soon skip that step. That's the typical approach. And if there's a good dynamic with the probationer and probation, they get it and they green light it. But I don't feel the need to have that additional level. I'm comfortable, and I may word it this way. You have to let your probation officer know. You don't just go to Kalamazoo, but send a text, call, however you're communicating with your probation officer to say, next week I'll be out of town for these 3 days. And he or she may say, hey, just email me your itinerary. And as long as it's not unduly burdensome for you, go along with it. But if you're finding that it is in some way constraining your ability to travel, let Mr. App know and we'll revisit it. Okay? So would I just do like a standalone order, or you've got a form that would modify probation?
Would Your Honor like to, so that I'm happy to save the court some time and effort, my staff can draft an order and send it to both you and Ms. Dilligard.
I always like saved time and saved effort. So why don't you have your team email to me, Ms. Nelson, and Ms. Dilligard that proposed order, and then I will make it mine, and then we'll see how that works with DCS. In the meantime, you should travel. I'm telling you now is okay, so that if for whatever reason your probation officer gets a wild hair about it and says, now we got to go to the judge, I'll say, I'm sorry, I didn't make it clear with probation, but I've authorized domestic U.S. travel for Mr. Robita.
It will be in our system. I'll make a note of report today.
Great.
It appears so
That's
that way.
very not.
I'm not, but yeah. Oh, sorry.
Sorry?
I'll make a note of it in the system so that his officer will be received.
Great. Okay. Mr. Apt, anything else on behalf of Mr. Robita?
No, I just want to thank the court and your staff also, because your staff was very helpful to me in getting this case in front of you, Your Honor.
Speaking of your cases, Mr. Logan is on our April trial calendar. I think that's our only case we still have together, but I know you're playing catch up across jurisdictions around the state and beyond.
You are so fortunate, Your Honor, that I don't have 8 murder ready announcements for you, because I was in Albany yesterday, I was in Catoosa County on Monday, and I'm getting called in all over the state.
I bet.
Yes, Mr. Logan's case should be a plea. It really should have been a plea 2 years ago, but
here we are.
Here we are. That was not a function of YSL or anything else, other than, it just, I don't want.
You've got Ms. Dilligard to work with now. It's her case, and now you've met her, so
We're
you
going to
guys
get that case resolved and off your docket, Your Honor.
Okay.
One way or another, we will.
Sounds like
I
a
don't
plan.
think it will. I am very confident it will not require a trial.
Okay. That's it. Good luck, Mr. Robita.
Thank you, Your Honor.
Thank you, Your Honor. And we will send that. I'm going to get email addresses, and then
Great.
We'll.
I know you had mine because you sent an email about this case, so you got that. You just need to get, I guess, Ms. Dilligard. All right. How are you two? Did you, I want to make sure I didn't miss calling you. Are you here for someone on the calendar? Who would that be? All right. We're waiting for his lawyer. Mr. Chang will be here. He estimated around 10:15 or 10:30. And then we'll take up that issue. Are you also here for Mr. Cassels?
No.
No.
I'm sharing the bridge. And I have a court date here with the legal.
Okay. If you'll get that to Deputy Gordon, we'll figure that out. All right. Which revocation should we just go through the calendar, start with Mr. Dorr? All right. If we could bring Mr. Dorr out.
I'm sorry, might be something a little technical in the mailbox. I've been having issues with my mailbox.
That's okay. You're here. We've got your case. So Ms. Wood is your lawyer. She can chat with you. You don't have court today. You have a final plea date, and Ms. Wood can tell you what that means in April, about a month from now. And then you're on a trial calendar tentatively in June. But I'm going to make sure you get your papers back, and then you and Ms. Wood can chat. She may need to get new contact information for you. Okay? All right.
Oh, The podium, oh.
Hey, Mr. Dorr, if you come on up to the podium, please.
Morning, how you doing?
I'm doing all right.
Okay.
How you doing?
Can you angle the podium screen up a little bit, please? Great, thank you. All right, good morning, Ms. Rivers.
Good morning, Judge. How are you?
I'm well, yourself?
Okay.
Good. We're going to go on the record on position 11. That's 15 SC 138285, State versus Kevin Dorr. Am I pronouncing your name correctly?
Yes, sir.
Mr. Dorr, he was here in court with his lawyer, Ms. Rios. And Mr. Dorr, I signed a probation warrant in your case in January of this year. And it alleges that in last December, you committed a new crime. It was obstruction of law enforcement in Astel. That was supposedly on the 9th of December. And then fast forward 3 days, I guess you got out, because on the 12th of December, you allegedly committed another crime, which was possession of a firearm by a convicted felon, and that was here in Fulton County. So basically, the probation allegations are that you got arrested for two different things in the month of December. None of that is consistent with being on probation. You have about 7.5 months left on probation in your case. And we need to work through today what the consequences are of those arrests. So Ms. Rios, is Mr. Dorr stipulating that he was arrested? Is he admitting? Has he already resolved these cases? What's the status?
So they're still open. He is stipulating that he was arrested. He is saying that those dates are wrong.
Okay.
But he has been arrested on those cases.
Okay. Is he in custody right now only on the probation warrant and not because of either the firearms case or some hold out of Astel?
That's what I believe. Let me just double check. This.
So I'm not sure. I found the firearms case here in Fulton, and that date looks pretty correct. You went into custody on December 12th or 13th of last year in Fulton. I'm just looking at the ticket. You were at Donnelly Hollowell. You got shot.
Yes, sir.
Okay, so you were shot, people show up, there's a gun in the car, your car has bullet holes in it, but because of an old case, you weren't supposed to have a gun in the car. I mean, that's sort of the summary. I don't want you to say that is what happened or it isn't, but so that date seems like it's a okay date. You're saying the Astel situation was a different time?
The date the incident happened that I was shot was on October the 17th.
Oh, yes, September 17th.
September 17th.
Oh, okay. Got it. You were in a Tesla and the owner, this young lady, she shows up. So were you just in the hospital for a while because of getting shot?
Yeah, they took me to the hospital and I left. I didn't know I had a warrant.
Okay, got it. I see the disconnect now. So you weren't arrested until December. I'm sorry. Yes, December, but the situation was in September.
Correct.
Okay. It's an open case. It's sitting out there. I don't know what the state's going to do with it, but there is this allegation that you had a gun in connection, I guess, with you getting shot. Where'd you get shot?
In the arm.
How's your arm?
It's good.
Okay. All right. So Ms. Rios, Mr. Dorr is stipulating to the two arrests, Astel and here in Fulton. Now I understand the timeline a little bit better. What are you recommending? Is there context you want to give to me about how Mr. Doerr's been doing or what's going on in his life or what?
Yeah, and to answer your earlier question, the probation, I believe, is the only thing that's holding him in right now.
Okay, that's what it looks like.
He is 38 years old. He's from Georgia. He has one child who's 12 years old. He works at Lee's Tree Service as a train operator. Crane operator. He lives in Austell alone. I'm asking for him to be revoked 1 month and terminate the balance. I know probation is acting for 6 months because there was a gun in the car. I'm not sure where the gun was found in the car because of how he went to the hospital, and they seem to have searched the car later and recovered a gun, but not on his person. So I'm asking for it to be for the time that he's been in be revoked.
Okay. And probation is saying 6 months. Is probation recommending then closing out the balance rather than having him be on probation for another 45 days? Got it. Okay. Ms. Dilligard, what's your view on how we manage this?
Judge, I'm in agreement with probation based off of 2 new offenses and one of them being a firearm. And so the state would also be recommending to revoke 6 months and to terminate the balance.
Okay. Mr. Doerr, do you know the status of the Austell case? I can't look that up because it's not a Fulton County case.
No, sir.
Have you been to court on it at all?
No, sir.
All right.
I mean, I made bond on it.
Got it. Did you go, Austell is in what county?
Cobb County.
Cobb County. So did you go from the Cobb County jail to the Fulton County jail?
Yes, sir.
So I guess that's how this gun warrant caught up to you, is that you were in Grady, you get out, you didn't know you were wanted. But when you had whatever your situation was in Austell and went into custody, they ran your name and said, wait a minute, Doerr's got to go down to Fulton. And then I see you bonded out in that as well. Looks like in early January.
Yes, sir.
Okay. And then I guess you bonded out just 3 days later. But then you got arrested in February on this warrant.
Yes, sir.
Okay. All right.
One more thing, Your Honor, I do want to say he has been on for 10 years. It looks like aside from late last year, he hasn't had any issues on probation.
Okay, let's confirm that. Ms. Simpson, I don't know if you're able to peer into the distant past of Mr. Doerr's case. Any issues before today? Okay, all right. Your child stays with, is it a boy or a girl?
Girl.
Does she stay with her mom or a different relative?
With her mom.
Okay, where?
Columbus. I usually get her every other weekend or at least once a month.
Okay, she'll stay with you.
Yes, sir.
Got it. All right. Well, Mr. Doerr, you're going to need to sort through both these new sets of allegations. The one in Austell don't sound super serious. The one here is not the most serious thing, although you got shot and you had a gun, or at least there's a gun in that car, and so you can understand why people are concerned about what was going on, why someone's shooting up the Tesla, why is there a gun in the Tesla? It just sounds dangerous for everyone involved. And you were on probation at the very end of your probation when that stuff happened. Mr. Doerr, I'm going to revoke 3 months of your probation. You'll get credit for the time that you've been in, and I will close out the probation when you're done. So when you get out, you're not on this probation anymore. You'll need to figure out what's going on with the Austell case and this Fulton charge. You don't need to do anything until the state decides, if they do, if the district attorney's office decides to turn it into an indictment, they can. But if they don't, it's in their office right now. Okay. All right. I'll fill out that paperwork. And as I mentioned, you've already done a third of your sentence. Thank you.
Thank you.
Mr. Chang?
Morning, Your Honor. How are you?
I'm well. How are you?
Doing well, doing well.
Have you had a chance to speak with Ms. Dilligard, who is the prosecutor on the Cassell's case?
No, Your Honor.
Okay. Then before we bring Mr. Cassell's out, I'll make sure you two talk a little bit so Ms. Dilligard can understand a little bit about why you think the bench warrant should be set aside.
Yes, Your Honor.
And we can take it up once the two of you have had a chance to talk.
Thank you.
Okay? Why don't we do, you've got all the cases. I was gonna say we could do Mr. Arnold's cases because Mr. Render is on, and that would free you up, but it won't free you up. Why don't we do Mr. Arnold, those two cases, then we'll take a break so you can speak with Mr. Chang and we'll pick up the other pieces. Good morning, Mr. Render.
Good morning, Judge. Always a pleasure.
Same. We will bring Mr. Arnold out in a minute. Have you already spoken with him about what you're going to be pitching on his behalf?
Yes, Your Honor.
Okay. Then I guess we can bring him out.
Thank
He
you,
can
Judge.
come to the podium, please.
Mr. Reynolds. Hey, how you doing, Mr. McBurney?
Hey, I'm doing well. Just a sec. You can be here. All right, let's get on the record in Mr. Arnold's two cases. He has position 12 and position 14. We'll just build this one off of position 12, which is 17 SC 153471. Mr. Arnold is here in court. His lawyer, Mr. Render, is appearing virtually. And we have Ms. Dilligard for the state. Mr. Arnold, you have about 2.5 years left in your older case, the 17 SC, and you've got a little less than 3.5 years left in your newer case, the 22 SC.
Sir.
In February, so just last month, I signed 2 warrants for you, probation warrants, the allegation being that on January 2 of this year, you committed a new crime or crimes, aggravated assault and battery. So the alleged basis for you violating your probation is getting arrested again. Same basis in both cases. And we need to figure out what we're going to do today about that. Mr. Render, is Mr. Arnold stipulating to having been arrested for the aggravated assault and battery, or is he contesting that such that we ought to set this down for an evidentiary hearing?
He is contesting, Your Honor. The allegations are, from my client's perspective, bogus. There's little to no evidence to support them. From my understanding, Your Honor, I had a couple of options. I wanted to see if he could be released with the right to bring the criminal law violation back if he pleads to that. But we would more than likely ask for a hearing. But I want to see what the state's recommendation would be with the charge, because he has been incarcerated since about January. So he's only on about 2.5 months in, Your Honor. But I do believe he's been out for 20 months. He's been released from prison for about 20 months. He hasn't had no issues. This issue was with an individual he was dating at the time. And from my understanding, things went left. But from my understanding, the evidence is not there at all in this matter.
Okay, well, I don't want to get into the evidence right now. Mr. Arnold, why were you in prison a while ago? Was it for one of these two cases or a whole nother case?
I think you ran a lot of stuff concurrent. You looked out for me last time. But I ain't been in no trouble, Mr. McBurney, I promise you.
Okay.
It's all bogus, like.
Okay, well, we're not getting into the substance of it, but Ms. Dilligard, if Mr. Arnold were to say today, look, I stipulate that I was arrested for these things, what is the state recommending?
For the revocation, Judge?
Yes, ma'am.
It would be to revoke 2 years and to terminate the balance on this 17 SC case and to reinstate on his 22.
Okay, well, it sounds like we should have a hearing then, because if the state does prove up these allegations, that's a pretty hefty revocation, 2 years, and it may be exactly the right revocation. I don't know anything about it other than I hear both you and Mr. Render that you don't think there's a lot of substance to the allegations, but I hear that a lot from people. And I'll just need to see what the evidence really is. And if there's nothing there, then we need to get you on your way. And if there is something there, then we get you on your way in a different direction. Mr. Render, I will have Ms. Nelson work with your schedule so we know when you can be here in court, because with an evidentiary hearing, I don't want you on the screen. I want you here with Mr. Arnold by your side. Ms. Dilligard, any sense of how long that hearing would be to prove up by a mere preponderance the allegations of the warrant?
Judge, I don't believe it would be long. I've looked like very briefly at the allegations. I don't believe it would take very long. If anything, we'll have 1 or 2 witnesses.
Okay.
And Judge, just wanted to answer your question for the record. My notes indicate that he was revoked back in 2022 previously on this case, and he was revoked 2 years then. Oh,
okay. So when you say you haven't been in trouble, you were meaning since your revocation, you hadn't been in any trouble.
I just got out of prison, man, incarcerated. I go to work every day. I'm trying to just get back home to my daughter, Judge.
Yes, that's correct, Your Honor. He's been out for 20 months, and this is the first incident he's had since his release. And I would anticipate, again, maybe 30 minutes to 45 minutes at the most. Again, I don't believe there's much there, so it wouldn't take long.
Okay. I see now how the pieces fit together. So it looks like the older case is where the revocation was, because the newer case, the 22 SC, was basically this case with Spagner and Farley. Okay. That the newer case was the basis of the revocation.
Yes, Judge.
Here it is. Let's see. Okay. We will do just that. So, Mr. Arnold, we'll get you back here soon so we can have this evidentiary hearing, and we'll see how that flows. Okay? All right. Thank you.
And Your Honor, do you know about how long that would be? Would that be 2 or 3 weeks, or?
I don't. It's really going to depend more on your schedule. So Ms. Nelson will reach out to you and say, here's the date. Or if she sees leaves of absence, she'll build it around that. But now that we have a feel for how long it would be, we'll just find a time slot for that, set it down, make sure you and Mr. Arnold can be here.
Understood. I'll come see you, Mr. Arnold, to explain everything.
Okay.
Thank you, Judge, for accommodating me as well, because I'm in like
No
2
problem.
at the same time.
All right. Take care.
Always a pleasure.
All right. Why don't we take a quick break so Ms. Dilligard, you and Mr. Chang can speak. Then we can take up Mr. Cassell's situation, and then we can do, is Ms. Recchi here yet? Do we know? I guess you'll need time to bring her up so I can. We have Mr. Leach to do. I think that's it. Okay. All right. I'll come back out in a few minutes.
The
That's what I did. But it's a situation where this is my understanding. It still doesn't have. You have this. You just go something that's a plan. So then, there's this girlfriend sometimes when he's there in that area, I'll still do it. He also was outside of the mob. Okay, but my opinion, having the lifestyle is a different people. But go and follow that risk.
That was fast. I got the door revocation order. They are, I say they, Ms. Burns, from our office, who is the one who designed that fillable PDF. She had to revise it. There were some good ideas about adding like a balance suspended checkbox, et cetera. And so she put it in Word format and sent it back to Chief Carlton. So I don't think it's been turned into a PDF form yet. But I want to make sure that when it is, it gets pushed out to you because you're using the old version. Just because they haven't, it takes some effort to turn the Word into a PDF. And Ms. Burns didn't want to do that until DCS management had said, yes, you've made the changes we'd like to make.
I think there was some more, thing that you found after this.
Good.
So, yeah, we haven't gotten finished.
Okay, and they'll be back and forth. It's a new form and there'll be tweaks. But she just wanted to leave it open for tweaks before she sealed it up again.
Correct.
But you will make sure that that goes out to all.
Tuesday, we received it back from her.
Okay,
We found some things and noted on there, so.
okay, so there's a good back and forth with her. Okay,
Yes, sir.
excellent. Are you all ready to go with Mr. Cassell's?
Judge, yes, I just need a quick moment. I believe I'm going to consent to setting aside. I just want to check his criminal history.
Okay.
Yes. Yes. Oh, yes, thank you.
Okay.
You ready?
Yes, Judge.
Okay, so you should say something. I'm like, hey, why is she standing up?
So the criminal history that I have is a little outdated, but nothing is jumping out to me as concerning. After speaking with defense counsel, I think the issue was an address issue.
Okay, well, let's bring Mr. Cassell's out and we can talk about that. Can he come out or do we need to get, is Ms. Rios back there? Okay. Hello, Mr. Cassells, if you come on out and stand next to your lawyer, please. Yes. I'm Judge McBurney. How you doing?
I'm doing okay.
So Mr. Chang is going to talk to me a little bit about your situation. You got picked up on a bench warrant because you missed court in December of this year. It sounds like there may have been an address mix-up. We'll see, but I'm going to hear from your lawyer and from the prosecutor on your case. And we also need to take care of moving your case forward, whether you're staying in or getting out. Mr. Chang, when you're ready.
Yes, Your Honor. Thank you. Your Honor, as the record shows, I submitted my entry of appearance on December 12th, 2024. Prior to December 12th, 2024, I was actually Mr. Cassell's immigration lawyer over at immigration court. And that's kind of what prompted my entry of appearance and my motion to lift the bench warrant back on December 12th. Because Mr. Cassell's is in the immigration court process, I talked to him about, like, if you have a pending case in Fulton County, you may want to kind of keep up to date with it because anything that happens in the criminal courts may have collateral consequences in the immigration courts. So one day I just decided to look up my immigration client's name in the Fulton County database. And I said, hey, Mr. Cassell's, I got bad news, but you kind of missed an arraignment 10 days earlier. So if you want, I can submit my entry of appearance and represent you in the Fulton County case. So after talking with Mr. Cassell's in terms of what happened, from what I understand is Mr. Cassell's, ever since April of 2022, which is when he got arrested for the charge of trafficking marijuana.
April of the year 2022? So this is an old case.
Yes, April 2022 is when he got arrested. At that particular time, even though I'm not sure there's a traditional definition of being transient in terms of housing, but at that time, he lived with his then wife in Ellenwood, Georgia, but he was kind of having problems with that particular relationship, including getting, according to him, wrongfully evicted from that particular house, I guess, due to problems he was having with his then wife. So at the time he was arrested for these charges, he was, for the lack of a better term, kind of transient. He didn't really have permanent housing. So the address that he gave to officers was this 3790 Fremont Drive, Ellenwood, Georgia, 30294, because that's really the only address he can come up with, even though his then wife had kind of kicked him out. Now, since then, from my understanding, they have gotten a divorce. Even up to today, he doesn't really have permanent housing per se in the traditional sense. I have his girlfriend here in court today. Whenever Mr. Cassell's here in Georgia, he will live with Miss Sharon over in an address in Austell, Georgia. And then at other times, he has a father in Brooklyn, New York, and he will live in Brooklyn, New York. He kind of splits his time between two places with girlfriend and a father, but he doesn't have permanent housing of his own. In my opinion, after talking with Mr. Cassell's, it seems like, father is blood, that doesn't really change. Having the Brooklyn New York address of his father is probably the most reliable, given the circumstances.
Except that it's in New York and not in Georgia. So we may need to find a healthy middle ground. Tell me, Mr. Cassell's, why you travel between Austell and Brooklyn. I understand you have a father there, but why would you not have one of the two places as your home base?
Yeah, because my father's getting older now, and sometimes I take care of him with one of my nieces.
What does older mean? How old is your father?
He's in his 70s now.
Okay.
76, 77.
Does he have other family in Brooklyn?
Yeah, I got his niece there and my sisters, but they don't take care of him, so I go there.
One sister or several sisters?
I got 2 sisters,
And they're in Brooklyn also?
and the one is in Connecticut.
Okay, and the other's in Brooklyn?
Yeah.
So same town as your father?
Yes.
And then a niece?
Yeah, that's my sister's daughter. She take care of him sometimes too.
Okay, so when you go to Brooklyn, it's to see your father, but also maybe help take care of him. How much time a year would you say you're in Brooklyn?
Maybe 3 to 4 times, like for a period of time.
Right, but how long would you stay? If you go to Brooklyn, are you there for a day, a month?
The last time I was over there for over a month last time. That's why I missed the court case too.
Okay. And how long what's the last name of the young lady here with you?
Herndon.
Herndon?
Yes.
With an H?
Yes.
Okay, how long have you known Ms. Herndon?
It'll be 3 years this month.
Okay. And Ms. Herndon, is Mr. Cassell's able to stay with you in Austell, or he simply visits you sometimes? And does he leave because you tell him to leave, or he leaves because he's a wanderer? I need to be comfortable that he has a place where we can find him. I'm not imposing anything on you at all. You may say, I'm not comfortable that having that be his official address, but I'm not comfortable having his official address in Brooklyn when we also, I'm gonna learn a little bit more about the immigration.
So I will make sure that he gets his mail. If he gets mail and notification, make sure that he will get it.
When he's not staying with you, you know where he is?
Yes,
Okay, so you'd be able to get word to him?
yes.
Okay. In a typical month, if there is a typical month for you and Mr. Cassell's, how often is he staying with you?
As often as he needs to.
Okay, does that mean that he's with you one day that month or 28 days that month?
If he needs to be there 28 days, it's 28 days.
Okay, and he is welcome all those 28 days?
Yes.
Does he pay rent?
He helps with, utilities.
He contributes.
He contributes.
Okay, talk to me about Mr. Cassell's work.
Your Honor,
Or he
I
can,
think-
either one of you.
Yeah, Mr. Cassell's is gonna have to answer that question.
Yes, Your Honor, I just recently been able to get a work permit. Because of this pending case, it's stopping me from getting a good job. I've been applying for like more than 100 jobs the past month.
Okay,
Because of this pending case, I think employees are not willing to employ me with this case pending.
it's a complicated time for someone who's not a US citizen to try to get jobs in the United States, I bet. I can only imagine. You say you got a work permit?
Yes.
As in from Immigration and Custom Enforcement, you got a work permit? Did you get that for him, Mr. Chang?
Yes, Your Honor, we've applied for employment authorization, which was just recently granted, I think maybe just about 2 months ago, 3 months ago.
Okay, what's your sense of the validity of that now? Things have changed a whole lot since there was a change in administration.
Yes, Your Honor, I understand due to the change of administration, the policies of immigration is probably could be different going forward. However, from my understanding, it does not change a legally issued employment authorization card from USCIS.
Okay, I would hope that's true. That's how it ought to be. I'm just curious because you're a professional operating in that space. If you've heard that the new administration is saying, well, we didn't issue that, so we're not honoring that.
I have not received any official notice from the immigration authorities that they're revoking previously validly issued employment authorization cards.
That hasn't happened yet.
Correct.
Okay, all right. Like I said, it's complicated times, Mr. Cassells. But whatever was issued to Mr. Cassells would authorize me, if I were a Georgia employer, to hire Mr. Cassells?
Yes, Your Honor.
In any field of work or only in the poultry industry or the aerospace industry?
There is no restrictions, Your Honor.
Okay, all right. Ms. Dilligard, tell me your thoughts. This one's a little complicated because Mr. Cassells is in he's in a gray space. It's not his fault, but he's in this gray space. It sounds like he's in a gray space in terms of residency, meaning literally citizenship, immigration, et cetera. It's also a little fuzzy with the Ms. Herndon situation. So I'm curious your thoughts.
Well, Judge, the state also shares those concerns about a good address, a good permanent residency for this defendant. I do want to note that the incident was indicted 2 years later, and so that was something that the state took into consideration when talking with counsel about setting aside the bench warrant. But I will note for the court that the state does have concerns about residency, and so we'll leave it in the court's discretion.
Okay.
And Your Honor, may I comment as well?
Of course.
And of course, Your Honor, I understand there has been one instance in which I guess the system did not work properly because normally Mr. Cassells received a bond back in April of 2022. And I know after the first appearance, the public defender that was assigned to Mr. Cassells, it maybe have done casually since it hasn't been indicted yet. But there was an attorney steward, there's just a steward on the record, didn't say anything else, that was assigned to be Mr. Cassells' attorney at that particular point in time. Since there was a bond, I presume he also has a bondsman as well. So there's really supposed to be 3 levels of contact with Mr. Cassells, the bondsman, the attorney, and himself. We've already talked about how, because of his transient address status, contact with him failed. Not really sure what happened with the other 2, but at this point in time, I myself has submitted entry of appearance. So for what it's worth, I would also receive notice and contact Mr. Cassells and inform of his obligation to the court.
Okay. So, Mr. Cassells, I will lift the bench warrant in your case, but I think I'm going to modify your bond a little bit and require you to be subject to pretrial supervision and require you to reside at the address in Austell, Ms. Herndon's location. And if you're going to travel out of state, you have to get permission in advance from pretrial services. It's not hard to do. You would just let them know, I'm going to go see my father, and here's my itinerary. And I might limit the length of the stay there, but I'll think about that you couldn't go there for a month, but you could go there for a week, assuming it's not an emergency. If something were to change and it's essential that you be in Brooklyn for weeks because your father has taken a turn for the worse, we could work through that. But for now, it sounds like he does have a support system there through at least one of his daughters and his great niece. And I am interested in keeping you fairly local, but you seem to be a little hard to pin down, and I need you to be a little more pin downable. This case ought not to be real complicated to work out. Either everything gets suppressed because it was a bad stop and search. If it was a stop, it sounds like things were found in a residence where you were staying. And if that stuff's coming in, There's not a whole lot of defenses to that, but you've got a smart lawyer and he'll think through that. Maybe we can sort this out soon. Complicating all this, of course, is your immigration status, because it may be that the state makes what you and your lawyer think is a very reasonable offer, but a felony conviction could make it much more difficult for you to stay in the United States. Going back to Jamaica is not a terrible thing. They're worse places to be returned to, but that's away from your father and from Ms. Herndon and others. So I understand that that could be complicated. Fortunately, your lawyer is handling things on two fronts. I meant to ask this, Mr. Chang. You said you're representing Mr. Cassels in connection with some immigration situations he has.
Yes, sir.
Was it simply to get that work permit, or is there an active removal action?
Yeah, Your Honor, unfortunately, I'm representing him in the Board of Immigration Appeals. So he already had a removal proceeding that was adverse. So I'm currently appealing with the Board of Immigration Appeals.
Okay, and was that removal proceeding predicated on the arrest in this case or unrelated?
Unrelated, Your Honor.
Related to criminal activity?
From because I came in after the removal proceedings, I came in at the Board of Immigration Appeals. From my understanding, it's simply Mr. Cassels came in, he presented himself to immigration authorities, he didn't have status. And then, no, I'm sorry, I take back, Your Honor. He overstayed a student visa, and then he had to apply for relief from deportation, which was unsuccessful at the immigration court level. So we're currently before the Board of Immigration Appeals.
Okay, so it was I won't call it a technical violation, but it was an immigration regulation violation that resulted in the order of removal, and then you're handling the appeal.
Yes, Your Honor.
Okay. All right. My request to you, Mr. Chang, is if you learn that the appeal is how quickly does something like that move?
It takes a while, Your Honor. It takes about a year, about a year.
Okay, so Mr. Cassels is going to be around for a little while.
Yes, Your Honor.
Okay.
And for what it's worth, Your Honor, if the Board of Immigration Appeals is adverse as well, there's other avenues where you can appeal to the federal district courts.
Oh,
So
okay.
that continues.
So you can lock that down for a while.
Yes, Your Honor.
All right. I'm not encouraging that one way or the other. I just, if Mr. Cassels gets removed from the United States, Ms. Dilligard doesn't need to work on the case anymore. And we'd put it in judicial hold, and it would be there to be resurrected only if Mr. Cassels returned. But it sounds like this will move faster than the ultimate appeal chain with immigration.
Most likely, Your Honor.
Okay. Let me check one more thing, and then I think we can be done. So the address of Fremont Drive in Ellenwood, that's the old address. You're not there anymore.
No, sir.
That's where there was maybe an eviction, ex-wife, whatever that situation was. Okay. Mr. Chang, I will need you to email to Ms. Nelson, who is my litigation manager, Ms. Herndon's address, assuming she is willing to serve as the official address of record for Mr. Cassels, because I'll modify his bond to require that as his residence. And if he is subject to pretrial supervision, he can't change addresses without pretrial supervision saying, yes, that new place you're going to is an okay place. So that keeps Mr. Cassels in a more known location.
Yes, Your Honor.
Okay. All right. Anything else on behalf of your client?
No, Your Honor. Do you need me to draft a proposed order, or does the court have a form?
I'll take care of that. I just need that data point. What is the address in Austell, down to the apartment number, whatever it is. So 123 Main Street or apartment X, it needs to be the precise place. We'll also update the system so that notices are going there, because it sounds like Ms. Herndon is good at tracking down Mr. Cassels. If he happens not to be there when a notice comes, one, you'll be doing that, but so will Ms. Herndon.
Yes,
Okay.
Your Honor. I'll verify with Ms. Herndon.
Mr. Cassels, I got one more thing to say to you, and then any questions from you, I'm happy to answer. If you miss court again, you will be staying in custody until you resolve your case. It doesn't matter why you missed court. You've used up your one miss. So there is not an excuse that is going to get you out of the next bench warrant. So don't miss court.
I will not, sir.
Okay, I'm not saying you did intentionally. It just really doesn't matter. If you miss court again, then you'll be unfortunately wearing that blue jumpsuit till we resolve the case, okay? Any questions for me?
Thank you, sir. I was going to say thank you for.
Okay, you're welcome. You should thank the prosecutor too.
Thank you.
All right, Mr. Chang, it's nice meeting you, and I look forward to working with you on this case. Last thing, we've got a waiver of arraignment form, and I'd ask you to complete that unless Mr. Cassels wants to be formally arraigned.
I would recommend that he waive arraignment. I'll take care of it. We'll waive arraignment. Yeah.
Okay.
All that means is your lawyer is entering a plea of not guilty on your behalf. He's going to fill out a form that then will require the prosecutor to give Mr. Chang all the discovery in the case, which would be police reports, whatever the police developed in connection with this case from almost 3 years ago. Okay? All right, you're good to go. You go with the deputy, Mr. Chang. Once you filled that out, just leave it with Deputy Gordon, please.
Thank you, Your Honor.
And can I see one of those? I want to make sure it's the new version that has the, is it the new one that has the discovery opt-in?
I haven't even heard him.
It does, yay, new version. So fill that out all the way, please.
Yes, Your Honor.
And make sure you get Ms. Herndon's address to us.
I will, Your Honor.
Thanks. All right. Did Mr. Johnson want to, we have to talk about setting aside his bench warrant.
Yes.
Okay. So
We have to talk about what he's got going on with that, 'cause I tried to look it up online, I couldn't talk about the actual part of it.
okay, so we need to talk with Mr. Johnson. We have Leach and Recky. Is Recky up yet? Is she in the building? Or should we do Leach? Don't take a break?
You don't have to bring Ricky up, Judge. I saw her last week and I'm gonna go back out and see her, so she's fine.
Okay, done. That was easy. I like making him do those things. All right, so what should we do so we don't lose track? Reset 30 days, reset for Ms. Recky.
If we could do 30 days.
Yep.
Ms. Ross is already plugging in, so I think 30 days will be appropriate, Judge.
Great, okay. So then we've got Leach and Johnson. We can do that in any order you want.
Each, I just want to discuss some things about him. Might have to reset him. I want him out here for that discussion to see what's the best thing to do.
All right, let me see his warrant before we do that. This is Mr. Arnold and Recky Leach. Here it is. So his arrest is a year ago. Has that been indicted yet? Yes.
He has this word.
In non-complex, you said? What's the case number?
I think it's assigned to Judge Kraus.
Yeah.
Okay, wherever it is, what's the case number?
24 SC 005451.
So really, the revocation could go there. Doesn't mean we can't handle it here, but it depends what's holding him in. If the only thing holding him in is this warrant, we need to deal with it. Unless he also wants to resolve the Judge Kraus case, which means we could send it there, or I could take the plea on the Judge Kraus case. And it may not be today that we do that, which I guess was your point, that we may need to bring him back.
Well, it was actually for a totally different reason.
Oh, okay.
He got interviewed by Hope House, and we're waiting for that acceptance. Ms. Ross emailed to fill out the decision at the end of the day. He is homeless, and so if he's released now, I'm not confident he'll get to Hope House.
We wouldn't release him now. I'm curious why you both have recently lined some folks up for Hope House. Why not drug court? They do the same thing. Hope House is more intensive. It's residential, but drug court has transitional housing for the first 90 days, and then they can be extended in a different location. But generally, we get better results / have better supervision, so that when someone walks away from Hope House, we get a probation warrant 6 months later, because Hope House doesn't tell probation right away. When someone walks away from drug court, I get to sign a warrant, and they have an ankle monitor the first 30 days anyway. And my goal isn't, hey, how can we lock them up sooner? It's really the longer term, how do we ensure that they're plugged into treatment longer? And generally through drug court, we are able to ensure a longer, if it's going to work, you have more assurances that it's going to work, which is not a knock on Hope House. Hope House is where we turn to in drug court when we need residential treatment. But they can go together. So I'm curious why.
I've seen a lot of people to drug court. I'm pretty sure
You guys are great with drug court, but I'm just feeling.
he wanted a better way, and we didn't do a better way for some reason. I think Ms. Ross decided Whole House out of what between their discussions ended up being Whole House. He told me the person from Whole House came and said they would accept him, but Ross said she didn't have a letter yet. So, and we can't handle the other case. It's a conflict case on the cross. That's a conflict attorney in that one.
Oh. Okay.
So I guess I can only do the probation revocation.
Okay.
So I am not sure what we should do on, because he's been in for a year. They're asking for a year to be revoked. So he technically should be getting out. If we go with that, then I don't want him to be released.
How's he been in for a year? The warrant I signed was in July. He was in for a while before the warrant?
Yeah, so he has some paperwork with him back there, so I couldn't get all of it. So he's been in custody continuous since March of 2024. Was in Fulton County.
That's a year.
And then went to Gwinnett County from June to October 24. Then they sent him to prison, and then from prison he had come here.
Okay. Let's see what it says here. He's had probation issues before on this case, it looks like, because he was in for over 200 days back in 23 on a probation issue. Has he been revoked in this case before?
Judge, I see 2 revocations in this case.
Okay. Oh, yeah, here's one right here on August 23rd, 2023.
He's been revoked, I think, like 4 times.
Okay, and he has still almost 4 years left. Mr. Leach does need treatment. Oh, so Judge Richardson did the last revocation, and that was for a year. Judge Richardson. Oh, he's been in, why is he with? One second. He can't, he's already done accountability courts. So that's one reason why. Oh, okay. I don't know why Judge Richardson handled the revocation. Maybe she was being helpful. This is a Judge Reader case, so it's my case. I just was saying it needs to go back to Judge Richardson if this had been her case. But in 21, I guess maybe he was in behavioral health treatment court. That's the only thing I can think of because Judge Richardson keeps signing the things, but we've stopped doing that. It's supposed to go away from the accountability court judge after someone is terminated. They handle that first revocation. And then it goes back to the judge who had the case, which would be not Judge Reader. Okay, so this is where it needs to be. And drug court is not where he can go. Thank you. Thanks, Mr. Chang. And he can't go to Hope House quite yet. He's frustrated because he wants to get out today, or he gets it that we need to have these pieces in place.
He wants to go there. I think I don't know if the best thing is to reset him to like a calendar that we have next week and give it a little bit more time.
That would give you time to pin down he has been in for over a year. It's not showing this
He
way.
has paperwork with him.
Have you looked at the paperwork, or does he do one of these things and say,
The paperwork is a little confusing. They have the release date, but the paperwork, I mean, it's a legit paperwork. He didn't write it up himself.
okay, it's not written on toilet paper?
But it's confusing.
In jail 1 year.
Because it says from 23 and release date to 25. I was like, why did it say that? But it's legit where he got it from. But I have, like, only thing I was able to get on my own was the fact that he was in a Gwinnett from June 2024 to October 24. I got that directly from Gwinnett. I did do a request from DOC, but they haven't given me the paper. Gwinnett seems to be quicker.
Okay, well, he was here, I can see he was here from March 11th of last year through June. So that's the release to Gwinnett.
Yes.
But then he doesn't make landfall here again until February.
Yes, and during that time, he was in DOC.
Okay, all right, well, as long as there's paperwork that shows that. And is the thinking Hope Hall, but continue him on probation? Just so that there's a little assurance that he goes to Hope Hall?
Yes.
Okay. Should I chat with him saying we're gonna see him in a week, or is it work better if you talk with him?
I think he will probably just quickly we don't have to explain everything. We just tell him we're sitting for a week to wait for Hope House letter. He'll get it because I kind of did a pre-chat.
Got it, a pre-chat, okay. We can just bring Mr. Leach to the door then, please.
Can we, Mr. Carter's having a medical issue, can we take him down?
Yeah, so we'll take a quick break.
Take about 5 minutes, after we do.
We can do Leach real briefly? Okay, let's just get Leach to the door, and I know we only have one thing left, but we'll take a quick break so Mr. Carter can get taken care of. Hope he's all right.
Hey,
Hey, Mr. Leach, you're good right there. I'm Judge McBurney. I know you've been working with Judge Richardson more than you've worked with me. Your case, though, originally was with a judge named Judge Reeder, and I've inherited all her cases. And so that's why you're back. I say back, that's why you and I are working together. I know you were in behavioral health treatment court for a little while? That's why you were working with Judge Richardson. But the case is back to the division that originally had it. And Ms. Rios has been doing a lot of work on your behalf. And she has helped me understand your situation, which is you've been in custody now for almost a year. Maybe in 5 days, it'll be a year. And Ms. Rios and her team have fully lined up a room and bed for you at Hope House. Is that a program you're willing to participate in? All right, well, I'm open to that idea as a result of the revocation that we'd be doing. But it sounds like the paperwork isn't quite complete with Hope House. They need to get a letter to either Ms. Ross, who you may have met, or Ms. Rios, who you were talking with today. And once we get that letter, that's confirmation. Nope, we've got a bed. It's got Mr. Leach's name on it. And then we're going to either bring you back here in person or get you, we do some sessions where you go to one of those booths at the jail with a little Zoom screen, and we can finalize everything we're going to do. And then I'll sign a transport order that gets you to Hope House. And then you need to commit to staying in that program. Because if you leave it, they let me know, and then I just sign another one of these warrants and we repeat this process all over again, okay? All right, so we're not quite there. My guess is as early as next week, we'll either bring you back here in court, get you on the screen, and try to tie this one all up, okay?
Yes, sir.
Any questions?
No, sir. Just thanks, sir.
All right, don't lose that paperwork that shows where you've been the last year, okay? All right, hold on to it. See ya.
Thank you, sir. You have a nice day.
You do too. So, Ms. Rios, do you want us to try to pin down a date now? I don't mean now like we talk about it, but that Ms. Nelson should go ahead and pick a date next week that she can make it work? Or should we wait until you get this letter and then you send her an email saying, please put him on the net? Because no one needs notice. You're going to be in court, I'm going to be in court, and we just bring him over.
Should have get the letter by the end of the day so I could see the email, but we also very quick 3 days next week, I think. So
What a good week for you.
Yeah, so maybe
You need more candy.
yeah, maybe the Yeah, maybe the 11th, we could put him down for.
So I'm not committing Ms. Nelson to any of that, but she and I will talk about it and we'll make sure he is brought over one of those days next week.
Send the letter, I'll email it to you.
Okay. Got it. We're gonna take a quick break. You let me know when we can come back out and we'll close. You say that, just let me know. And we will take care of Mr. Johnson. And I think that's it. Ooh, quick calendar. No, please. What are you guys doing?
What is that?
The account records request.
No. How'd you do that?
Plus I have this for.
Are you trying to get proof of incarceration?
Yeah.
Oh, I just like take a screenshot of their like booking stuff. Like the public available.
Oh.
Yeah, because it's just quicker that way.
Where do you go?
Go to the Georgia Department of Corrections and there's a find an offender.
Oh, yeah, it's a great tool.
It's amazing, yeah.
Yeah,
It's way
you get a picture. It lists all the other times they've been in custody with DOC.
Yeah, so click on that.
And they really look different. Stanley Porter, after they took care of his hair,
They shaved it.
he looked much less like a creepy child molester.
Wow.
Yeah,
Yeah, so submit the form.
he should have done that before trial.
Yeah, okay. And look, scroll down.
Oh, yeah, we are together 3 times next week.
Yeah, so it shows where you maxed out on February the 2nd.
Yeah.
So is this?
So one of your cases went to the consolidated criminal trial. Have you had one on there before?
Oh, no.
So I won't ever double book you. We only have 1 week of calendar here, but that week overlaps. But we may, when we have the discussion about what's going, agree that Titus and Ford, that's what we're going to do the first week. And it would either be here or Emerson. I control what goes first here with Judge Emerson's calendar. I'm pretty far down the list. Judges get to go in the order of the number of resolutions they've had on his calendar. And there are a bunch of judges who have resolved fewer cases through Judge Emerson. And so you may never get the email will come from me, just coincidentally, but I'm the one who does the scheduling for the Emerson calendar. And so you get an email from me that says week 1 consolidated calendar if your case is on it. So if you never get an email from me about that calendar, you don't ever need to go to 1D. And it goes out about a week before the first week and then a week before the second week. I'm trying to remember the other case. Oh, we put Dandridge? Yeah. So
Say that we never get to the top of the list, but I feel like we get there all the time.
we don't the first week. We usually do the second week. And so my goal is actually to try Dandridge in front of Emerson week 2. And I cleared it with Ms. Wood that she's okay, even though we may go forward with one of her cases during our trial week, she's all right doing back-to-back with Dandridge. And I would do the same with you. If we had a messy calendar where I thought you might be going here, I'd make sure, hey, if we did X, are you okay being on the Emerson calendar as well? There are a bunch of judges who they match theirs up with it. And so they say, I'm gonna call my calendar. And if you say you're ready, but Emerson is ready on that one, that's where you'll go try it, because then I can just turn to another case on my calendar. It gets a little tricky when it is your line ADA and one of your PDs who's down there, because then there are fewer of my cases that I could go forward on. But you don't need to worry about, well, wait, Judge, I can't be in 2 courtrooms at once. So there you go. And Judge Emerson's a nice guy.
Lazy just explained that to me yesterday.
Like, how do I juggle this? But you're right. You of all people have Judge Whittaker, the rankings, I keep a little list. Judge Whittaker has resolved the most, and just because for whatever reason she puts it on there and they plead.
Mm-hmm.
Whittaker, me, McAfee, and we're sort of in a league of our own in terms of put it on there and stuff gets taken care of. Either it's a trial or it's a plea. There are some judges who don't look in their dockets and they send stuff there, and the attorney has 2 weeks off that, and so you don't get to substitute it. Once you submit it, that's your case on the calendar. And so, poof, you don't get a resolution because you didn't look and there was a leave of absence for those 2 weeks. But
I think there's some judges that rarely send cases there.
Also true.
Yes.
Right. Don't know why you'd pass on the freebie. It's been an amazing resource.
If we get cases there that wants to take a plea, we have to take the plea with Judge Emerson?
Nope.
Can we come back here?
You can, if you can get on the calendar here. And plenty of judges do that. That still counts as an Emerson credit. So Judge Whitaker has taken a lot of the pleas of the cases that she put on there, but that was a way to put trial pressure on a case. Or she may be one of the ones, I don't know, where she double schedules it. And so it's on her calendar as well. And so they just naturally took the plea in front of her. And then I get an email from her litigation manager saying State versus Jones has been resolved. She gets credit for a resolution and that comes off that calendar. So if you can convince the judge who submitted it to take the plea, you can always do it that way. And I'm happy to take the plea. What, you don't have a case on there?
I do. You put Titus Murphy.
Oh, Titus Murphy is you. That's right. Okay, but he's also on our trial calendar.
Yeah.
So work it out. And next Thursday, we could take the plea.
I'm going to try.
Good luck.
See, the April trial calendar is out. It's
like 2 pages long.
I
What
know,
the
I'm
heck?
scared. That looks
Miss
scary.
Nelson.
I'm like, what's happening?
No, she and I had a long conversation. What's happening is you guys are resolving your cases. She dredged and scraped and said, what else can we put on there? I had her carry, it would have been even shorter, but I said, you know what? We're not going to resolve Gill, Williams, and Dandridge all at once. So put them also on that calendar because one of them will probably carry over. It also, the way things cycle through, it's a little bit of a lull. I think May will be bigger because there'll be things that didn't get resolved that bounce across. It is time to try that case that had Tanya Miller on it and now has,
Oh, I know who you're talking about.
but that murder is, that's my oldest jail case now. And that needs to be tried, a couple others. And I think they're going to pop up sort of May, June-ish. And we still have to move that one that Miss Feely still has, the 4 defendant.
Oh, yeah, she's itching.
That's what, that guy was beaten to death. It's not a shooting, it's not a stabbing, just someone or some group of people beat the man to death.
I saw Mr. Cherry pled yesterday.
All his cases.
Incredible.
Yep. 1 body down, 4 left, 2 in Clayton, 2 in Jacksonville.
Yikes.
It was super calm. He's like, yep. And it was life in this case, life in this other one. He's like, well, will those life sentences run concurrent? Everything's running concurrently.
He was always like when I had him, he was always my easiest client.
I don't know what the on switch is for that guy, but when that on switch flips, I mean, what Mr. Abadi was describing, he was doing 9-inch shank and.
Yikes.
At the attorney, she mentioned when we stepped out while they were waiting in the room, she said he asked for the death penalty.
As in he wanted that.
Mr. Cherry, and he was like, I want the death penalty. She was like,
Can't give you that.
we can't do that.
Yeah.
We can, let's just work something out.
Let's aim a little lower. Yeah, and the sheriff was so anxious to get him out. Like the moment you sign those final dispositions, he's on his way.
Yikes.
Yikes is right.
Okay.
He'd been in jail since 2020,
Oh, yeah.
nonstop.
And like back and forth between
Clayton.
Oh, yeah. And you talk to him. No, I didn't.
So we did our first adjudication of guilt forms too. That's such a funny form. I get why you guys need it, but it's never done something like that before. I guess it allows you to close out the previous probation because it's not really being terminated. It's getting a whole new sentence.
Do you remember what it was that the resolution? Okay, got it.
On the bottom of that form, was all that information needed on there?
No, and Ms. Carlton said, couldn't you just remove all those blanks? And the pushback was, no, just leave them on, but unless a judge is saying fill them out, you know, it's the defense attorney bar number, all that, especially on that form. That's a form that is seldom used and it's purely for your purposes. I can see why you might want it on like a revocation order. In fact, we're thinking about adding a signature line for a defendant on the revocation order, so that he thinking about getting these signature pads, like you do if you're going to a doctor's office and initialing things. It's just a little screen with a line on it, sort of like when you're signing a receipt, but it's not a whole iPad thing. It's smaller and cheaper. If a defendant signs the revocation order, it's a whole lot harder for there to be a discussion later on saying, I didn't know that was one of my conditions. Your signature's on it. Same with the final dispositions. Every single final disposition has at the bottom a blank that says defendant signature. He's really supposed to sign it because it shows all the conditions and it makes much more effective the Fourth Amendment waiver. Right, but it ought to be right then there so that the judge can say you sign it in front of me. So we're seeing about how that technology would work. We don't want to create more of a paper trail, but if there's a way where a defendant could electronically do it and it slaps it onto the final disposition, you can skip that step when they come and check in with probation. We good? Ms. Rios, tell me what we need to chat with Mr. John. Oh, the bench warrant.
Yes.
So before we bring him out, what is, Mr. Leach was very pleasant, by the way. Oh, he was in jail somewhere and we need to work through, well, that might explain why you weren't here, but that doesn't mean everyone is super excited to have you back on bond. Yeah. So before he comes out, walk me through what happened.
I am not sure why he was in Gwinnett County. I was trying to look it up, so I wasn't able to talk to him about that.
Okay, I guess we can ask him. Let me just get his file open here. So he missed plea and arraignment in December, but was in custody. And let me look at what his bonds are. They were not old. He had been on bond.
Like his criminal history.
What is this?
Wow,
it says his the consent bond that the state entered into, he didn't make bond till September of last year. It says he was assaulted at jail and has a severe brain injury and he's to be taken to the appropriate treatment facility. Did he tell you about any of that? This would be interesting. Let's bring Mr. Johnson out, please, to the podium. You've been talking to this guy?
Yeah, I was at the jail and I wasn't. Where's
This
he not?
giant hairy pot. Hey, Mr. Johnson.
Good morning or good afternoon.
Good morning. Slide that way a little bit.
Yes, sir.
All right. Mr. Johnson, I'm Judge McBurney, and your case is assigned to me. You were supposed to be here for, I'm on the wrong screen. I think it was plea and arraignment in December of last year. You missed it. Ms. Rios has been telling me, but we'll talk about it with everyone here now. You were supposedly in custody somewhere else.
Gwinnett County, sir.
Okay. Well, we'll talk about that in a second. I just need to figure out where you've been and where you might be if you get a bond. So you were in jail here. It sounds like someone beat you up while you were in jail?
Nah.
No?
They kind of did, but I didn't report it or nothing to the police. Right now, I'm just trying to get home.
Okay. Where's home?
Like a hotel or apartment or something. I'm working on it right now. My boss just got my money. The 2 checks went through like 5,000, 6,000. So I finally came in through now.
What are the checks from?
I got hit by a truck in Tequila.
Okay. When did you get hit by the truck?
It's probably like maybe 18
Okay,
or 19, somewhere around there.
okay. And did you have a head injury when you got hit by the truck? Or was it your legs or your arm?
It was just a mirror, it knocked me off, but, you know.
Okay. And you've been getting some payments as a result of that?
Well, my lawyer finally got my payments. He went to court and went on it. So, but I was gonna check the only reason I had checking my PO, because, you know, I was working every day. You know, I do scrap metal. So I was making money regardless every day, so.
Got it. So you made bond here. I think you actually got what we call a signature bond. You were released, and then you got locked up in Gwinnett?
Yeah, I was going back and forth probation out there too. But I'm on felony probation.
In Gwinnett?
Yeah.
For what?
I don't remember.
Okay, well, we'll be able to look that up. Were you in jail in Gwinnett for a little while?
Yeah.
Why?
Just temporary misdemeanors, you know.
Pardon me? Misdemeanors.
Yeah, like non-reporting to probation and stuff like that.
Okay. How long have you been on probation in Gwinnett?
I have no idea. Because usually I let my attorneys handle it.
Were you on probation before you got hit by the truck?
Yeah, I think, yeah.
Got it. All right. And did you get released from Gwinnett, or were you brought from Gwinnett straight here?
Gwinnett straight here.
Okay. When you were released, when you made bond here in September of last year, did you go straight to Gwinnett jail, or were you released to the street?
Nah, I went back to work.
Went back to scrap metal work?
Yeah.
Okay. All right. Ms. Rios, why don't you walk me through what you think I ought to do here with Mr. Johnson's situation?
Yes, Your Honor, I'm asking for the bench warrant to be set aside since he did not voluntarily miss court. He was in custody at Gwinnett. Sounds like for probation, revocation, and possibly a misdemeanor. And I don't see a history of FTAs of him not missing court. Now, I don't have an address for him, but he said he'll be able to get me that when he is out because he's had all this money from the person he's been working for. I will make sure he has my number so he can call me as soon as he gets to a phone so I can let him know about any upcoming court dates.
Okay. Good morning, Ms. Jackson. I appreciate you being on the call.
Good morning, Judge.
Can you share with me criminal history information on Mr. Johnson?
Yes, Your Honor. He has 28 cycles. The last arrest was September the 23rd, 2024 in Gwinnett County for a probation violation. He does appear to be on first offender probation in Gwinnett County for aggravated assault. That disposition date was August the 6th, 2021, and the term is for 5 years. Also, he appears to have an additional misdemeanor conviction. He's on probation in Gwinnett County for misdemeanor terroristic threats and act. That disposition date was March the 12th, 2024, and the term is for 12 months. In addition to that, he appears to be on probation in Fulton County. That case number is 24 CR 001439 and the letter G for public drunk and unlawful to conduct during a 911 call. That disposition date was April the 9th, 2024, and the term is for 12 months. He does have prior misdemeanor convictions. One in 2019 out of Florida for DUI and obstruction of an officer. One in 2021 out of Hall County for battery. One in 2017 out of Gwinnett County for simple battery. One in 2009 out of Duluth, Georgia for DUI. Nothing in addition, Your Honor.
Thank you. So, Ms. Simpson, sounds like Mr. Johnson should be in your system for the Gwinnett case. Do you see that? Okay. And is he being out of what jurisdiction is he being supervised? Okay. He has an officer?
Yes, Judge, Officer Kennedy.
Okay. And what was the revocation for that just happened? It sounds like in September of last year, he was arrested for a probation violation.
It appears he violated criminal laws by being arrested for a new offense of disorderly conduct on January 22nd, 2022 in Barrow County, and as well as a technical violation of the changes.
Okay. Got it. Ms. Dilligard, what are your thoughts about Mr. Johnson's situation?
Judge, the state was consenting to set aside the bench warrant due to the fact that he was in custody when he missed court. I did take into account these new arrests when providing Ms. Rios with an offer to try and resolve it. But otherwise, the state has no objection to setting aside the bench warrant.
I missed one part of what you said. You made an offer to resolve the case, or you said the offer not to oppose the
An offer to resolve the case.
Got it. Okay. So, Mr. Johnson, tell me where you think you'd go if you got a bond.
Well, I'll be like between Gwinnett and Fulton County. You know, because the main thing, I didn't show my POs. That what fucked me up. My bad for my, sorry, it's been a long day.
It's okay.
I've been in jail with a lot of crazy people, but so I get out of jail this time, go see my PO in Fulton and tell her about my PO in Gwinnett and get them all working on the same side.
Got it.
You know,
Got it. PO in Fulton because that's misdemeanor probation, not felony probation.
No, and then I got misdemeanor and felony in Gwinnett. So if I get everybody on the same side, I can knock this out.
Okay. Got it. So, Ms. Rios and Mr. Johnson, here are my thoughts on this.
Yes, sir.
I think that I do need I ought to set aside the bench warrant because Mr. Johnson didn't willfully miss court. But I'm not particularly inclined to keep in place the signature bond that got him out. In interacting with Mr. Johnson, hearing about all the fairly recent, some of it's quite recent, run-ins he's had with the authorities, want to try to connect Mr. Johnson with some resources that might help with whatever he's wrestling with. Alcohol, drugs, who knows what. But in looking at why he's here now and some of these other charges, the very, very recent conviction out of our sister court downstairs, it seems like connecting Mr. Johnson with resources rather than hoping as he bounces between Gwinnett and Fulton and not quite sure where he's going to stay, he'd be better off starting out with treatment in place. I will defer to Ms. Ross and your thoughts, Ms. Rios, about what that would look like. But it would need to be part of the bond. I'm not saying you need to work the case out. This may be a terrible case for the state and they ought to dismiss it and apologize to Mr. Johnson. But if I'm going to release him on bond, a condition of that bond will be participation in some form of treatment. And I don't want to just say, go find treatment. That's not fair to him. And so I'm going to ask you, Ms. Rios, to put your head together with Ms. Ross, and obviously Ms. Ross will want to talk with Mr. Johnson about that. That may lead naturally to a resolution. Great if it does, but I don't want you to think, judges twisting our arm to work the case out. I'm happy to make that a condition of bond. And the bond dollar amount isn't my focus. I don't know that you can do UJR for terroristic threats. Assume you can. I won't keep Mr. Johnson in custody because he can't post the bond. I will keep him in custody until there is a support system in place for him when he gets out, be that through a bond or through, well, one second, I promise I'll hear from you, through diversion. I'm happy to do virtual PTI. We don't have to wait for the DA's program, or through a plea. It's not like, well, I guess he's on first offender. It might be his first felony, so that might be a reason not to do that. But I will let you guys think about that, and I'm happy to bring Mr. Johnson back here as quickly as necessary, just like with Mr. Leach, if and when something's been lined up. So you understand what I'm saying. You got a question, you want to push back?
I'm a retired cop and a retired lawyer. You just stopped and retired last year, so. But I'm saying my dad's gonna help me out when I get out this time, out of jail, you know.
Okay. Well, that may be ultimately what you and Ms. Rios bring back to me, is that Mr. Johnson's going to be with Mr. your father, and that's the structure.
How much more time in jail do I have to do?
Not much. Ms. Rios will talk to you about it, but I want to be real clear. It is so that Ms. Rios, and you may meet Ms. Ross, the name sounds similar to different people, Ms. Ross, to talk to you a little bit about what you've been wrestling with. You've been arrested a bunch of times for public drunkenness, this and that, and I'm not critical of that. I am wanting to get you help with that, because we're not helping you to say, great, you're out there and your dad, he can't be with you 24/7. And then we get another situation. Gwinnett's going to come down pretty hard if you get arrested again for something. I'm just letting you know how they roll there. And you don't want that. And you could lose your first offender status. Aggravated assault's up to 20 years. And so if they took away your first offender status, resentenced you, it could get messy.
Well, I have a white attorney out there in Gwinnett too, so.
Good.
He's working with me.
Bet you got good resources. You got your dad on your side. Most importantly, you've got Ms. Rios on your side. So she's going to talk with you a little bit. And as soon as we've got a plan in place, whatever that looks like, then we'll talk again, either in person or they've got these booths out at the jail and we'll get you on a screen. Okay? All right. Thank you. All right, Ms. Dilligard, I think that covers everything on the calendars. Do you have anything else?
I do not, Judge.
Ms. Wood?
No.
All right. Ms. Jackson, thank you for joining us. We will see you or a colleague next week when we're back in action. Appreciate it.
Thank you. Have a great one, Judge.
You too.
So there's no trial calendar.